Okay, let's go on the record. This is the matter of Gale Cooper versus Lincoln County et al. CB 2007-1364. Let me have your credentials for the record. I'll know for the record, Dr. Cooper is present in the court. Okay.
Good afternoon, Your Honor. Desiree Goulet, substituting for Mr. Kevin Brown on behalf of Mr. Sandoval and the now deceased Mr. Sullivan.
Okay.
Good afternoon, Your Honor. Henry Narvaez with the Narvaez firm for Lincoln County, and Rick Bearden, Lincoln County Sheriff.
Okay.
Also present with us today is Mr. Alan Morrell, the attorney for Lincoln County.
Okay. All right. And we're here on Dr. Cooper's motions. I'll just let her get started.
Your Honor, I'd like to bring up something before we discuss this matter. The notion of the sad fact of Tom Sullivan's passing, and I move, if it's agreeable, that we dismiss and stipulate as to dismissal under Rule 41 of Tom Sullivan, since he's passed away. And so I wanted to bring that up first.
Right. And any objections to that, Counsel?
No, Your Honor.
No, Your Honor.
Okay. And I was reviewing the file, and I did see the suggestion of death had been filed just recently on that. Okay.
It was in October that he passed.
Right. Yes, and they filed the suggestion of death about a week ago, on the 10th.
Could that be prepared by
Oh, it's already been filed.
The motion to dismiss?
With the court's permission, Your Honor, I would be happy to prepare it.
Oh, thank you very much.
All right, okay.
Thank you.
Good.
Well, we're here today on my motion for costs, damages, and under IPRA law, and then potential sanctions. I brought a copy of a case that just occurred last month that I thought might be of interest to you and as well as my colleagues here. In the Second Judicial Court under Judge Clay Campbell, there was a very similar decision, letter made in November 21st concerning damages. That was a Jennifer Vega Brown versus the Bernalillo County Sheriff Dan Houston, and it's how he thought through the award of damages, and it's so pertinent that I brought a copy for everyone. Okay. May I give that?
Here.
Thank you.
It was also in the papers, but his decision letter is after that. And I'll be referring to that. Well, today is hopefully historic. It has to do with the enforcement of statutory civil penalties on what's arguably the most extreme case of Inspection of Public Records Act, or IPRA, violation in the history of this state. In the 6-year litigation that I've been present in, and in which I'm a plaintiff, all records that I requested have been willfully and wrongfully withheld. That was done in defiance of the IPRA statute, in defiance of orders, and defiance of my fundamental right to inspect public records. That failure to give me records is completely unjustified. No valid IPRA exception was used for my denials, and no IPRA deadline was met. In IPRA law, that's it. There are no other safe havens. My co-plaintiff, through subpoena, proved that the requested records did exist. The fact is that I could have gotten those records within the 15-day time period of my first records request on April 24th of 2007. There was no reason that I wasn't given those records. This litigation was not necessary, and during this litigation, at any day, I could have been given the records right up to the present. If I can't get enforcement for IPRA penalties in a case like this, I can take this beautiful cornerstone of democracy, the IPRA manual, and get rid of it, because no other citizen should go through what I've had to go through on this case. The law would have no teeth and no value. Now, I didn't need a reason to request these records, but I have one, a very big one. I'm exposing the murder case in Lincoln County called 2003-274, called by its promulgators the Billy the Kid case. I'm exposing it as a law enforcement fraud and DNA hoax, jeopardizing Billy the Kid history, and doing it by illegal exhumation with fraudulent DNA. The purpose was a publicity stunt to prove that Pat Garrett didn't kill Billy the Kid, even though that's not true. The reason I bring that up is twofold. One, it speaks, though I don't have to under IPRA address it, it speaks to the motive of what has happened for the past 6 years. My defendants simply didn't want me to see the records. The records are not compatible, the actual DNA records, with the claims that they were making. Claims that would allow them to claim they had the DNA of Billy the Kid, the reference DNA, and conduct illegal exhumations using it. Since I've been questioned so often in this court, this is my next edition that I'd like to put with my other ones if the court would accept it. This is called Cracking the Billy the Kid Case Hoax. This is the case that we're dealing with. It's almost 1,000 pages of labor on my part exposing this. May I give a copy to the court? Because you have my earlier version, and it's been questioned about repeatedly in this courtroom.
No objection, Your Honor.
So I understand, is it proposed that the book be part of the record or an exhibit or?
A courtesy copy, whatever. This isn't a evidentiary hearing, but I've been questioned about the book so much, and my commentary.
I'm just trying to understand.
Yeah.
It'll be a courtesy copy, but not part of the actual court record.
That's fine.
In this book and in this case, I want to make clear to the court my extensive knowledge. It definitely is expertise, as came up in the February 4th evidentiary hearing this year. I'm behind all the IPRAs that were ever done in this case. That's 10 years of IPRAs, 6 years in this court. I've been given no records, just deputy cards once, but the excuses were different. In addition, I'm behind blocking the exhumations of Billy the Kid and his mother. And I brought in the Kennedy Hahn law firm in 2003 and 2004 to achieve that. Now that brings us to the records that I asked for, because they're not random and they make sense as to why they're difficult for the defendants to give to me. They were their only way they could continue case 2003-274 after I blocked the exhumations. Their premise had been that Pat Garrett didn't kill Billy, and that would solve their murder, and in our record preserved are their probable cause statement and their petitions for exhumation. But after those graves were blocked, they were going to say that the DNA of Billy and his mother didn't match. Well, they had no DNA. They had to come up with it. So central to continuing the hoax was the carpenter's bench on which Billy the Kid, they alleged, had been laid out, bled, and preposterously was only playing dead for the coroner's jury and for all the townspeople of Fort Sumner. And he headed off into the future as one of the claimants to his identity. They were going to use DNA from the carpenter's bench to match the claimants and thus indirectly solve the murder, because if a claimant was claimed to match that DNA, then Pat hadn't killed Billy on July 14th of 81. Billy survived, and Pat was, again, the murderer of an innocent victim, which is what case 2003-274 is about. So the records I asked for, quite purposefully, were Dr. Lee's specimens for DNA that he collected from the carpenter's bench as the first unfulfilled records request. Second was Orchid Cellmark Laboratories DNA extractions from Dr. Lee's specimens. Third was Orchid Cellmark's DNA extractions from Billy the Kid claimants who were dug up in Arizona, one being John Miller, the other being a random man buried beside him. And the fourth was the matchings of Orchid Cellmark DNA from the bench to the claimants. And as to, by the way, I can give that as a reference for everyone to know. Those records are listed here. Guys. Those records are listed in my initial complaint in this court and were in my request. My April 24th, 2007 request, those four items. As to IPRA law and precedent cases, they support the maximum penalties that I'm requesting today. IPRA is a very idealistic law and made for citizens. Its section 14-2-5 states, quote, "It is declared to be the public policy of this state that to provide persons with such information is an essential function of a representative government and an integral part of the routine duties of public officers," close quote. The landmark case in New Mexico is a Court of Appeals case in 1977, Newsom versus Alarid, and it says, in short, that IPRA intends to let citizens determine if their public officials are, quote, honestly, close quote, performing their function as public servants. Implied in that is a welcome to be a whistleblower and to root out dishonesty in performing their function as public service. This court has already made its decision for liability for me. Summary judgment was given to me on November 20th of 2009, with its order being March 12th of 2010. It stated that my requested records were public and created by the defendants as public officials. On September 28th of 2011, those material facts were elaborated, and the order by you, Your Honor, stated that Billy the Kid's killing by Pat Garrett and the deputy killings by Billy the Kid were a single case, 2003-274, by the Lincoln County Sheriff's Department. Importantly, my defendants in 6 years have given me and this court no contrary evidence whatsoever. There are some main authorities for the damages and for the violation itself. One that is very important because it goes to the heart of the argument that, or one of the arguments that the defendants have presented. That case is a New Mexico Court of Appeals case from last year, Toomey versus Truth or Consequences. There, the court ruled that, quote, absent any express exemption from disclosure, public agencies must produce all records, even those held by or created by, I repeat, held by or created by a private entity on behalf of the public agency. Well, since our IPRA law is silent on exactly the meaning of behalf of and the test factors, our Court of Appeals sought Florida law. That's a Supreme Court case in 1992 called News and Sun Sentinel versus Schwab, Twitty, and Hanser. And what they were looking for was deciding factors. Two of the factors are applicable here. quote, when services are an integral part of the public agency's decision-making process, and the second is for whose benefit the private entity is functioning. And the court cautioned when they made this decision that it's immensely important that an avenue not be opened for potential defendants to contract with private agencies to conceal records that they would like to hide. In this case, this was remaining, this DNA was the only remaining way, an integral part of the Sheriff's Department's solving of the murder of Pat Garrett and the innocent victim, and for whose benefit it certainly was the Sheriff's Department, since Orchid Cellmark is the biggest lab in the country. They're not doing research on Billy the Kid. More importantly, both Dr. Lee and Orchid Cellmark identified their work as going to case 2003-274. Now, Rio Grande Sun versus Jemez Mountains Public School District, again last year in the New Mexico Court of Appeals, addressed the purpose of damages, stating that granting plaintiffs costs and damages encourage, quote, socially beneficial litigation. I would say that saving the history of New Mexico in regard to the iconic Old West, Billy the Kid and Pat Garrett, and saving its attendant tourism certainly rates as socially beneficial. Board of Commissioners of Doña Ana County versus Las Cruces Sun News, our Court of Appeals in 2003. The legislature's punitive intent in imposing a cost for non-disclosure is evident. Punitive here is taken to mean deterrent. San Juan Agricultural Water Users Association versus KNME-TV in 2011, a Supreme Court case said that IPRA's damages provisions are considered as effective remedies and are intended to, quote, encourage public entities' prompt compliance and facilitate enforcement. That's the key, prompt compliance. It's the only teeth in IPRA. Faber versus King this year stated in the Court of Appeals judgment that prevailing plaintiff is entitled to per diem damages from the first day of noncompliance with the records request until the day of proper denial or compliance. Now, as to the broader notion of sanctions for impropriety, which I also brought up in my motion, I'll just cite one case, and that's United Nuclear Corporation versus General Atomic Company, and that's our New Mexico Supreme Court, 1880. Quote, when a party has displayed a willful bad faith approach to discovery, it is not only proper but imperative that severe sanctions be imposed to preserve the integrity of the judicial process and the due process rights of other litigants. The importance of IPRA is you're not just doing it for yourself. I didn't join the state to my case, but I could as easily be any citizen in New Mexico standing before you and trying to exercise my rights. What about the defendants? This United Nuclear case talks about willful bad faith. What I've gone through, what this court has gone through, is a willful withholding with no statutory basis or facts. It was done by misstated law, false statements, double talk, and shell games. I want to give everyone a copy of this because it's only a fraction of what I'm going to refer to. First, I want to say, I might as well give this now because I'm going to be referring to these are the shell games, and this is a courtesy you have. Good. Defendant Verdon is the undisputed records custodian. He produced no records whatsoever. All the records that I asked for were generated in his tenure beginning in 2005. He gave me no proper written denial. IPRA is very specific on exactly how a denial has to be valid. He used no IPRA exception. He ignored this court's orders. all of his responses were unreasonable, which is a polite word. This court saw me questioning Defendant Verdon on exactly a year, December 18th of last year, about the turnover file that I had subpoenaed from him under subpoena ducis tecum for his September 2008 deposition. After claiming he had no records, he produced 193 pages. Of course, they had no DNA records, but what I pointed out to him is they had a contact list that was passed down from his predecessor, Tom Sullivan, who started the case, and had all the necessary information to get me the records within the 15-day time limit. And IPRA is kind to people receiving requests, and you can ask for a burdensome request to have extra time. You have to ask in the 15 days. That was never done. They just said that the records couldn't be gotten, which is not anything to do with IPRA. But what happened, it got worse. 3.5 years after my request, 3 years into this litigation, under pressure from this court, I would contend, Mr. Verdon began to make gestures which is supposedly were to look like records requests. On October 26th of 2010, he sent one letter to Dr. Lee, and again I questioned him in this court, to Dr. Lee and to Orchid Cellmark. How did he identify the case with this litigation number, not 2003-274? What did he ask for? He had the list in my request. He had the list in my complaint. He knew what the records were. He asked for a floorboard report, which I didn't request, about Dr. Lee, and he asked for reports on blood, which they had fabricated anyway, and I certainly didn't ask for it. Okay, but he said Billy the Kid, so they knew what he was talking about. They second-guessed it, and he got answers, and those were submitted to the court. On November 12th of 2010, Dr. Lee said, yeah, I have a report. And Orchid Cellmark said, yeah, we have a report or reports. Just get in touch with the client of record, our client, and get them released to you. So there they were. The reports existed. What did Sheriff Verdon do? Nothing. Nothing. That has nothing to do with IPRA at all. That has to do with trying to trick me and this court. What Sheriff Verdon would like us to believe is that as a 40-year lawman veteran, 4-time sheriff, state police department worker, he had no idea how to get his own lost DNA records. DNA is totally common nowadays in solving crimes. They were the only way he could solve his crime. He had no idea what to do about it. Well, he said the records didn't exist. IPRA doesn't ask for your opinion. It just says get the records. So my co-plaintiff last year, apparently, I didn't participate in this, decided to create the material fact that the records did exist, so he subpoenaed Orchid Cellmark, and they gave some of the records, but it was a big pile, 133 pages. This court has them, and the defendants have them, and it was clear that Orchid Cellmark labeled them dually 2003-274 as the Sheriff's Department case and 4444 as their internal case. So what did I get instead? For 6 years, absurd excuses. My deputies took the records and they won't give them back. That's not an IPRA excuse. It's barely an adult excuse. They called IPRA law possession only. The definition of custodian under 14-2-6A is only 31 words long, and it says very clearly, as the Toomey case established, that a custodian is responsible for his records regardless of whether they're in his actual physical custody or control, and it's further expanded under public records themselves in section 14-2-6F, in which public records are defined as records even if they're held on behalf. We've just had shell games. They're shell games of switcheroos and changing the words. A very good example is criminal exception. The 4 years I did IPRAs before this case, all my records were denied based on using the criminal exception, which is 14-2-1 A-4. We have that preserved in the record in a request letter that I did through my agent, journalist Jay Miller, a letter to him by Sheriff Verdon dated November 28th of 2005, and that's the letter in which he confirms that he deputized Mr. Cedarwall and Sullivan to do the Billy the Kid case, 2003-274. He denies me all records based on the criminal exception. Well, why wasn't it used here? Because it admits that they're public records. So they had to concoct the preposterousness of my deputies took them, and I don't know how to get them. These people could not possibly be that foolish and conduct themselves in life, certainly not in their jobs. We saw worse. Under questioning by my attorney, Bill Verdon, you saw my past attorney, Martin Threet, question, and that was in one of the hearings. That was the hearing on sanctions and past attorney's fees on January 17th of last year. We had Attorney Threet read the letter that he sent to me on September 12th of 2010. The letter said, Henry Narvaez, who was then Verdon's attorney and still is, Henry Narvaez assures me that if you dismiss Sheriff Verdon, he will get you the records that you want. IPRA is not about let's make a deal. IPRA is simply give me the records. I refuse to do that. Well, they submitted findings and conclusions to this court, which in the light of the summary judgment are more for the use of the court and optional, but they're a very good summary. That was April of this past year of the stance that's being taken by Defendant Verdon in a purported dispute with me in the court, apparently. What is it? Merely fabricated facts, fabricated IPRA law, and no case law at all. Possession only is claimed. They preposterously say, why didn't I come to the Sheriff's Department and look at the records when there were no records in the Sheriff's Department? IPRA isn't come and visit and look in our files in the pocket of the custodian. IPRA is, if we have the records, you can either see them or we'll send you a copy. That's not IPRA law. The findings and conclusions opine about Dr. Lee and Orchid Cellmark's DNA. IPRA isn't about opining. It's not the custodian giving their opinion about the records. It's producing the records. Then they have a very nice example of the shell game. They do a reversal. They say that Verdon is not Lee's or Orchid Cellmark's records custodian. Of course he's not. They're his agents generating and holding on his behalf the DNA records of case 2003-274. He's the custodian of the records. That's a game. Then oddly, they deny that records exist in that findings and conclusions when they have in hand Dr. Lee's admission that he has it, as well as my co-plaintiff's 133 pages that are not even the totality. What about Defendant Cedarwall? This court has already ordered, but I'll go over it again. He's a commissioned deputy for 2003-274. The games that were played around that involved NSMA section 14-41-9, which had to do with his responsibility. As a deputy, he's authorized to discharge all the duties that belong to the sheriff as if they were executed by the sheriff himself. another game that was played, because there were shell games there too, that he wasn't compensated. UJI 13-401 NMRA states, quote, an agent is a person who represents the principal with or without compensation. And this court wasn't taken in by that. But just to emphasize Mr. Cedarwall's records responsibility, he's listed on a deputy on all official documents, on the exhumation petitions for which all my defendants claimed standing, based on being law enforcement, and for the Arizona exhumation of John Miller. He even, in the recovery phase, before this litigation, admitted to withholding the records from me. That was his memorandum, which is preserved in the record of June 21st of 2007. But how did he justify that? He fabricated for the first time, for my request, and I knew because I did all the IPRAs, that he was a hobbyist all along. Well, what about the evidence for it? In 6 years, they've said it over and over again, and we don't have a stitch of evidence. You have hundreds of pages of my exhibits showing the official capacity and none. An important example which shows the game in action was my questioning defendant Cedarwall this past February 4th in the evidentiary hearing about the critical element of the records I'm requesting, the carpenter's bench. He admittedly wrote the probable cause statement for case 2003274. So he wrote, and I had him read, that as Lincoln County Deputy Sheriff, he found the carpenter's bench. The Maxwell family, in whose house Billy died, had claimed to have it, and Mr. Cedarwall contacted their family. It says, Deputy Carpenter's Bench, you wrote the report. How did he get out of that? And that's one of the records. He said he didn't feel like a deputy in his mind. And it's important to remember that, because it's impossible to get these defendants to fess up. As to IPRA itself, it gives no leeway. You can recall, as I said earlier, 14-2-5 says in responding to IPRA request, it's a, quote, integral part of the routine duties of public officers. It doesn't say just the records custodian. Anyone who was part of the production, holding, any relation to the records can become a defendant, and that's why they're in my case. Poor Mr. Sullivan and defendant Cedarwall. This was his job to keep those records and turn them over as much as it was defendant Verdon's. 14-2-11B, in its very careful stipulation of how to write a denial letter, which they never did, states, quote, each person responsible for the denial has to be listed. I got no such letter, but Mr. Cedarwall was certainly responsible. Dramatically, he even admitted to forging and tampering Dr. Lee's report to remove the case 2003274 information, as well as the law enforcement titles, his being Deputy Tom Sullivan, who was the sheriff at the time. The investigation was done by Dr. Lee, removing his sheriff's title. That was stated in his deposition of June 26th of last year. That was a court-ordered deposition. That's a very important statement, and not just in the attempt to trick me in the court. I was given those forged documents as real, and this court was given different versions of those documents as real. He started turning them out in 210, like pulling rabbits out of a hat, as this court pressured. But the important thing, beyond tampering with evidence, is the willful attempt to trick me and the court. Those are not random alterations. Those are alterations that support his false contention that he was a hobbyist and that the carpenter's bench report was not done for the Lincoln County Sheriff's Department. What did he call that? Massaging. Okay, you're not supposed to massage records. You're supposed to give originals or exact duplicates of originals. As to the findings and conclusions that were also presented this April, they're also a good summary. They're as untruthful about facts and law as defendant Verdon's, but they have the personal lies. They lie that he's not a deputy for the workbench, lie that salary abrogates responsibility or lack of it, claimed that the 4 reports that I got from Dr. Lee constituted meeting an IPRA requirement for report turnover. I want to address the 4th report, which is called original in the findings and conclusions. It's not original. Mr. Cedarwall himself, in his deposition on the 26th of June last year, said it was the first report he got from Dr. Lee. It had the law enforcement information on it and the case number on it, but it was unsigned. My attorney then, Bill Verdon, brought that up in our hearings last year on sanctions. That was the May 31st of 2012 hearing, that it was not an original, it was unsigned, and also it was a reproduction because the photographs weren't in color. That pressure made them produce yet another version, this time on a CD, which did have the color pictures and the law enforcement, but had no signatures at all. The big picture is there was no fulfilling of my request. And we know that Dr. Lee not only told Sheriff Verdon that he had the record, but he told me indirectly in one of my IPRs through the journalist Jay Miller in a letter of May 1st, 2006. He wrote, I have sent my letter to the Lincoln County Sheriff, my report on the carpenter's bench and the floorboards to the Lincoln County Sheriff's Department. It subsequently disappeared into the ether when I made my request. They lie that the exhumation was private. I have given this court as an exhibit the supplemental report for Lincoln County Sheriff's Department exhumation of John Miller on May 19th, 2005, where the investigator is listed as Deputy, Lincoln County Deputy Steve Cedarwall, and he signed the report. Where did I get it from? I got it from the Prescott Police Department. I was participating with them in the in that investigation of that as a criminal case. And the deputy assigned to it, Anna Cahill, sent me the copy which she got from Mr. Cedarwall, because in that phase they were purporting and putting themselves forth as cops and law enforcement. That was before my case. They say that he's not the records custodian. It's true and irrelevant. They said he's not Orchid's client of record. That's true and irrelevant. The relevant thing is, as he admitted in his June 26th deposition, he knew who the client was all along. It's Calvin Osler, who assisted Dr. Lee and is his partner in doing that forensic business. Calvin Osler himself could just have been called by the defendant Cedarwall at any time, and we wouldn't have had to go through this preposterousness. What about Calvin Osler himself? There's been a constant attempt to mystify the client of record. When I was testifying in the evidentiary hearing on January 21st of 2011, you noted that you have a lot of experience with DNA and cases, so you would know that a client is merely a formality, the contact person, because many of the law enforcement departments are huge, 20, 30 people, sheriff's departments, all of whom need the records, or police departments, and one person for their records takes care of that. It's pro forma. Calvin Osler had no authority in case 2003-274 other than being the agent of the sheriff and being part of the chain of custody because the client mails in the specimens as well as giving a release. The big picture is his name should have been given from the start in the 15 days, and I should have had the reports years ago. They state oddly that I've not shown that these are public records, which is just plain perplexing, and one could say they have not shown that they're not public records. They also oddly say the records do not exist and then that they're trade secrets, and I think that is a hint to what's going on. This case, in its overall scope, was an attempt to privatize public records, keep them secret, and profit from it. And I don't have to make a big jump. This court has seen Mr. Cedarwall's website called thebillythekidcase.com, in which he was selling for $25 membership, in which he would send you records of case 2003-274. What's the magnitude of that and implication? In his deposition, he said, and that's June 26th of last year, that when the case started, that would be in 2003, Billy Sparks, Governor Richardson's spokesperson, said they got 24 million hits. Multiply 24 million times 25. My past attorney, Ed Threed, used to say to me about the defendants, if you have the facts, you pound the facts. If you have the law, you pound the law. If you got nothing, you pound the table. I've had to listen to 6 years of table pounding for unjustified referrals and spend my life with this. I'm now going to talk about the enforcement. This is enforcement for total, defiant, and willful noncompliance. I met the IPRA requester requirement of a written request. IPRA sets up an award of statutory penalties for wrongful denial of my 4 records request, and that's based on the legislature's intent to enforce transparency by setting strict timelines with penalties. There was no safe haven for my defendants. I do want to alert the court to a technical thing, though, and that has to do with Rule NMRA 7.1. My defendants, when I filed my findings and conclusions this May, filed no adequate response to it. They filed a joint response brief of June 7th, 2013. Would the court like a copy of that?
I have it.
You have that. It does not mention my motion. Instead, oddly, it merely refers me and the court to their findings and conclusions, which I've already addressed, as if the court and myself were supposed to make up the argument for them. There is no argument. It's only one page addressing this, and that has very important implications. If you fail to make an adequate response, that comes under 7.1D, which states, quote, if a party fails to file a response within the prescribed time period, the court may rule with or without hearing. Though it doesn't bear directly on a district court, just to see the magnitude of that position, the U.S. District Court of New Mexico in Local Rule 7.1b provides that a failure to file a response in opposition to a motion, quote, constitutes consent to grant the motion. I contend that this court is free to make my uncontested award, but I leave that to the court and just want to give the argument on enforcement. Faber versus King of this year in the Court of Appeals, the opinion stated that when IPRA damages are requested, it helps the higher courts, and in fact it focuses to say what the damages mean. Are they compensatory? Are they punitive? What are the damages? Well, they're statutory damages, and IPRA gives enough information to know what they intend. Section 14-2-8A calls them penalties, and there's a penalty if the written response if your written response is not properly answered. An oral request for records doesn't have a penalty. Section 14-2-10 goes over remedies pursued if the custodian does not permit records to be inspected in a reasonable amount of time. 2,415 days and counting is not a reasonable amount of time. 14-2-11 A, B, and C make clear the specifics of the denial letter that's required. And it's very serious because the denial letter is the stand that's being taken by those responsible for the records. It has to be produced in 15 days. It has to have an explanation, and that doesn't mean my deputies took them. It has to be a compatible IPRA explanation for why the records weren't given. The records have to be listed, and those responsible for the records have to be listed. By the way, in this case, I got no such letter, but more importantly, the defendants have repeated over and over that they have no idea what the records I requested are when they're in the request. At times, they called it one record of Dr. Lee. There has never been a statement by the defendants as to the records. Anyway, not complying subjects the defendants to per diem fines of up to $100 per day per records request. And I'm contending that by up to 100 is appropriate in my case. Section 14-2-12D makes clear that this court has the authority to act in this civil matter of IPRA enforcement, stating, quote, the court shall award damages, costs, and reasonable attorney fees to any person whose written request has been denied and is successful in court action to enforce the provisions of the Inspection of Public Records Act, close quote. Now, shall is an important word. It's mandatory. Derringer versus State in our Court of Appeals in 2003 stated, quote, the plaintiff is awarded mandatory costs, fees, and damages if the plaintiff is successful in action. Damages are not discretionary, but arise from violating the statute. And that's very important. They arise from violating the statute. Damages flow from the statute. You don't have to prove damages. You don't have to prove compensation. This is a penalty for violating the law. What about the damages? They have to be sufficient to achieve IPRA's purpose. They have to be a deterrent to stop the commission of IPRA violations. To use Old West imagery, I would say my defendants are now running like a horse with a bit in their teeth. They're running wild. Apparently, they feel they will not be touched by any penalties. As to my attorney fees under 14-2-12D, those were settled for all my past attorneys on March 26th of this year in the mediation. My ongoing costs as of today, and those are going to continue if the case continues, are $19,594.56. The per diem damages, and arguably there's never been anything like this in IPRA law in New Mexico, and there probably won't be again, are calculated based on the 2,415 days since my 4 records requests. I want to bring attention. 2007. My April 24th, 2007 records request.
So how many days total?
That is the 16th day after.
What you're saying, the total amount? You said 2,000?
No, that's the number of days.
What was the total?
Total? I haven't given it yet.
No, but you said 2,000, I got right.
Oh, I'm sorry, 2,415 days from the first day of noncompliance, which is May 10th of 2007 to today. And tomorrow it's a different sum of money. But let me call attention of the court to my records request through my agent, attorney Mickey Barnett, of April 24th of 07. I had him write in it, quote, each category of documents requested above is to be deemed a separate request to inspect the records identified in the category to the same extent as if separate requests had been delivered instead of a single letter. Now, that's one of the reasons I gave you Judge Campbell's decision letter, because the case was so similar. His wording of that was, for the Jennifer Vega Brown case, the requests were made in a single writing, but were 16 discrete requests. He elaborates on that later in his decision letter, which is very meticulous in sorting out the issues of noncompliance. He states that arguments by the defendants against the maximum per diem damages, quote, appear to shirk responsibility and shift it to the very citizens for whom IPRA's policy of transparency exists. Because after all, that's what this is all about. These are our public servants. What they're doing with the taxpayer money has to be transparent. I want to address, though, the subpoenaed records that my co-plaintiff did. He received them from Orchid Cellmark of April 20th of 2012, that was last year, and he got two of the categories, at least what they released to him at that point, addressed two of the categories, which were Orchid Cellmark Labs extractions from Dr. Lee's DNA and Orchid Cellmark's DNA extractions from the two exhumed bodies from Arizona. I might as well note here, because there was not a good place to put it, that as I mentioned in the findings and conclusions, they said that the exhumation was private. It's listed under case 2003274 as 4444 under Orchid Cellmark's DNA records. They weren't busy trying to conceal it in 2005, and so Dr. Lee's and the exhumation are all appropriately under the case. Anyway, he got the records. What does that mean in terms of my settlement? And I want to address it because it's a little bit subtle. First of all, Derringer versus State, a New Mexico Court of Appeals in 2003 stated, IPRA, quote, does not provide for damages pursuant to an action brought after a public body has complied with the act. Well, that's the key issue. My defendants did not comply. My co-plaintiff despaired of IPRA and went outside of it, exactly what IPRA is set up to spare defendants. But that doesn't mean it's compliance. It just means that we proved to this court that they were lying, that the records didn't exist. So they're still in non-compliance. What about the fact that I have the records now? Does that have any bearing? IPRA is pretty clear on that. There's no burden on a requester. I could have had the records all along and requested them, which I didn't have, but I could have. Section 14-2-8C in IPRA states, quote, no person requesting records shall be required to state the reason for inspecting the records. That was elaborated on in City of Farmington versus the Daily Times, a court of appeals in 2009 in our state, addressing the landmark case of Newsom versus Alarid of 1977. Quote, nowhere in Newsom does our Supreme Court place a burden on the party requesting the documents. Instead, Newsom clearly places the burden upon the custodian to justify why the records sought to be examined should not be furnished. And that's the issue. The records sought to be examined. There was no reason that they shouldn't have been furnished. That brings my total of $100 a day from the first day of noncompliance to today per 4 requests to a total of $966,000.
What was that amount again?
$966,000. So we have the costs at $19,594.56 and the per diem damages as $9,666. And those damages would be categorized as Faber versus King requested, as statutory civil penalties of per diem damages as mandatory fines for noncompliance. To finish the IPRA section, though, I want to bring up something that I haven't seen brought up anywhere else, and that's an elephant in IPRA's room. And I think it has a bearing on the courts evaluating damages in a case as egregious as this one, and that's the disparity of resources. IPRA's guide says, invitingly, quote, the legislature wisely created a large... Oh, I was nervous about the time. Tell me where you are, and I can back up.
IPRA's resources.
Oh, okay. The elephant in IPRA's room that impacts the ruling is disparity of resources. IPRA's guide says, invitingly, the legislature wisely created a large number of private attorney generals to help enforce the act. It is imperative that private citizens enforce their right to inspect records. Well, imperative means necessary and obligatory. So what happens if you become a whistleblower, as IPRA invitingly offers you? Well, a plaintiff is not a taxpayer salaried attorney general, just a layman personally and financially overburdened by conducting litigation of this sort. Meanwhile, public official defendants hiding records can get attorneys paid from an unlimited taxpayer pool forever. There's no ceiling at all. I've been doing parallel IPRAs on the payments on this case. There's no incentive to stop forever. The only incentive is the coercive deterrent of the statutory per diem damage penalties to force prompt compliance. In this case, it's not prompt, but hopefully force compliant. And otherwise, public officials with something to hide will use exhausting stonewalling as a defense tactic, which is exactly what I've gone through and what this court has been exposed to. My hope is that this court will now end the accrual of more per diem penalties and more of my costs. I would say that it's time for us all to move forward from this litigation. As to the non-IPRA sanctions, we had hearings last year on January 17th and May 31st about the forged records. The magnitude of that can't be underestimated. I contend that it was willfully done for concealment of evidence directly to this court. Starting in September 9th of 2010, my attorney Martin Threed brought up the issue of NMRA Rule 11 contempt for the total defiance of this court's orders for records turnover. The tampering comes under Rule 37 for discovery abuse of evidence tampering and obstruction of justice as presentation to me in this court as genuine or authentic of records tampered and forged to willfully conceal their connection to case 2003274 and its law enforcement titles. I want to finish with a quotation from the U.S. Court of Appeals in Denver, Colorado, in a case called Garcia versus Berkshire Life Insurance Company of America. It was a 2009 case, and the quote is, open quote, "It is hard to imagine that appellant would not have retrieved this information immediately had it consisted of beneficial rather than damaging material." I prepared an order for the court as a suggestion, and which goes over all of these issues. May I give copies?
Yeah, you cover the cost. Do you want to present them a copy?
Thank you. Will I have opportunity for rebuttal?
I'll give you some time, yes.
Yes, thank you.
Let's take a 5-minute break, and then we'll get started, okay?
All right, sir.
We'll take a water break of that.